Hello, hello, and welcome on to the folks who are joining. As you probably know from these webinars, we're going to have a little bit of early time as we let the room fill in and people start to get online, but we'll start in a couple of minutes, and I'm so glad you're joining us. I also love to see who's in the room on events like this, so I can see all your names. But if you're able and feel like it and are associated with an organization or any other cause, would love to see you rename yourselves, just so I have a good sense of who's there. But thank you all for coming. Oh yeah, I'm not sure if that's actually an option in webinar mode. Usually you can change your participant name and you can edit your name there. But if not, sorry for that instruction. Um, we will get started. I think it's about 5 past the hour. And I'm so glad that you're here for this call. As folks know, yesterday the Supreme Court heard oral argument in United States v. Rahimi, which would be the second big blockbuster case we're hearing as many years after Bruen came down last year. We've got 3 wonderful panelists with us: McKenna McBride from March for Our Lives, Perry Murray with the Newtown Action Alliance, and Joe Saccharin with This Is Our Lane. I'm your moderator, Tonga Leslie. I am Director of Policy and Program for Racial Justice with the American Constitution Society. And I also focus on gun safety and gun violence prevention and the Second Amendment there. I'd like to give a moment to each of our panelists just to share a little bit about themselves and also what brought them to their work. And then we'll get started diving into the substance. So first up, I'll pass to McKenna.
Thank you, Tonga. Hi, everyone. Thanks for joining today. My name is McKenna McBride. I am a legal associate at March for Our Lives, and I'm also a student at Columbia. So I became involved in youth activism actually in 2018 when Parkland happened. I marched on the ground in my hometown with March for Our Lives, just to end up joining the national team 4 years later. So it's bittersweet to be here. I realized I had been touched by gun violence in all of its pervasive forms, from firearm suicide to everyday gun violence in the communities that my family called home, and mass shootings as well. And so it just was really important for me to be able to integrate what I cared about into my work, which is why I love working for March for Our Lives and love being a part of this movement. And since then, I've just dedicated myself to ensuring that these next generations don't have to take up this fight at the young age and really have to abandon the innocence and childhood that we all wish we could have. So yeah, thank you for having me, and excited to hear from everyone today.
Thanks so much for sharing that, and both exciting and bittersweet. Wonderful that people are like getting involved in the grassroots, and also would be wonderful if we didn't have to. Could you introduce yourself, Poe?
Hi, everyone. So my name's Poe Murray, and I have been leading the Newtown Action Alliance since my neighbor killed 20 children and 6 educators in Sandy Hook Elementary School in 2012. Well, we're not well known across the nation as a gun control organization, but we're very well known in the gun violence prevention community. And we're very well known on Capitol Hill because we have been the bold, unapologetic, and aspirational organization in the gun control movement, pushing Congress to do their job. And we do that by working with survivors from all corners of this country who have been impacted by all forms of gun violence. And we've been pushing Congress really hard on two priority legislation, assault weapons ban and Ethan's law, to keep kids safe from unsecured guns. And we have seen success during last Congress when we passed both of those legislative proposals in the House of Representatives. And now we're working really hard on the Senate side. But we understand the intersectionality of this issue. That is why we work with our progressive partners like Demand Justice to make sure that we work on court reform, but we also, push for filibuster reform and other structural, democratic issues that will be needed for us to pass gun control laws and retain them. So it's really nice to see everyone today.
Thank you so much. And similarly, I'm at a loss, but a wonderful contribution to this work, and I'm really appreciate you being here. And I'll pass to Joe, if you can tell us a little bit about yourself.
Yeah, thanks so much, Tonga, and it's great to be here with all of you. And it's a really just, I think, sad state of affairs where we are currently in this country as it relates to this public health problem that we're facing. And I just, will briefly tell you that I come to this conversation not just as a trauma surgeon, but also as a survivor. I was nearly killed at the age of 17 when I was shot in the throat with a 38 caliber bullet. And, that moment really inspired me to go into medicine. It inspired me to become a trauma surgeon so I could give other people the same second chance that I was given. And then as I started going down kind of my professional path, I started to realize that despite, how good I may think I am as a trauma surgeon, or despite how excellent our trauma center is, when someone comes in that's shot in the head, there's very little that we can do to bring them back to baseline. And that's really what drove me to working, at the intersection of medicine, public health, and public policy, to really try to provide the best medical treatment, which is prevention. And I've been privileged to work with, people like Poe and McKenna and so many others across the movement to really think about how do we tackle this public health problem in a way that prevents these injuries from happening in the first place. And I am really excited to be here and look forward to this discussion.
Thank you so much for sharing on that. And I think I'm really glad we started with your stories. This case also started with a story before it became a dry legal issue. And the core of this is that Zaki Rahimi was not just accused, but actually has admitted to, or at least in the court findings, did not contest that he had physically assaulted his female partner. And there was a witness to that, and he had threatened to shoot the female partner if she told anybody about the abuse. She went to court and received a domestic violence protective order against Rahimi. And one of the terms of this protective order was that he was not to be in possession of firearms. And there is also a federal statute that allows for the disarmament of folks who are under domestic violence protection orders. After several incidents in which Rahimi shot in the air in public, including after his friend's credit card was rejected, there was a search warrant executed against Mr. Rahimi. They found firearms and they went to prosecute him under the statute. That would all be routine, except for Rahimi said that this violated his Second Amendment rights, and basically that the statute on its face was unconstitutional. And the Fifth Circuit agreed with him, and that brought this case up to the Supreme Court, which heard arguments on that yesterday. And so I want to pass to McKinnon, first of all, to give us a little bit more of the legal context on this. What is the legal context around Mr. Rahimi's argument that this is unconstitutional, the government's arguments that it is? And I also know that March for Our Lives got involved in this case, filing an amicus. So I'd love also to hear about March for Our Lives' position and how your organization ended up becoming involved in this litigation.
Yeah, would love to talk about this. So I'll start with a brief rundown of where we are as far as the Second Amendment, and how we've gotten to our understanding of it today, at least in the courts. And that really begins with the landmark Second Amendment case, which is DC v. Heller, which happened in 2008. So for the very first time in 2008, which always blows people's minds, but yes, in 2008, the court ruled for the first time that the Second Amendment enshrined an individual right to own a gun for self-defense in the home. And so then under a conservative majority court, rather than a conservative supermajority as we see today, that courts under Roberts with Scalia, Kennedy, Thomas, Alito, they all struck down a DC law that made it illegal to carry an unregistered firearm, and did not allow the registration of handguns for public carrying. And so in that case in 2008, Justices Stevens, Souter, and Ginsburg all dissented, and they all noted that the Second Amendment's inclusion of a militia, that prefatory clause that said, the militia being necessary for the security of the state, that meant something, and that we should only be giving people the right to a gun in the context of that militia. But instead, that conservative majority court at the time in 2008 basically struck that prefatory clause from our understanding of the Second Amendment and said, no, it's just the operative, just that the people have the right to bear arms, and that's it. So that's really what got us to this point where everything is unraveled from then, and we've seen this onslaught of Second Amendment litigation happening. And so most recently, last year, as I'm sure a lot of you heard, in NYSRPA v. Bruen, that was where this conservative supermajority court, still under the same leadership and the same author of the opinion with Clarence Thomas, the court struck down the New York law that required a person to show a special need for carrying a firearm on their person in public. So now we didn't just get them saying, you can have the right to a firearm in your home, you have the right to carry a firearm in public. And obviously this totally changed the landscape, but arguably more importantly, in that case, the decision introduced a new test for the courts deciding how a gun law is constitutional. So we no longer have the government being able to engage in a means-end scrutiny where they say, to protect public safety, we have created this narrowly tailored law that will make sure that we can curb gun violence, and that way it's constitutional. The court says, no, you have to find a historical analog. There has to be a law from the time at the founding that's similar enough to the law today that you're trying to pass or the law that you're trying to uphold, to be able to show that it's constitutional. And I can say, working in this space, that has been the biggest rewrite of Second Amendment jurisprudence in the country. After we get Heller, where you have for the first time a new Second Amendment right enshrine an individual right to a gun, you would think that would where we would see all of this Second Amendment litigation popping up after, and all this confusion in the lower courts. I can say more than that now, after what happened in Bruen last year with that rewriting of the test, we have seen a wave of litigation, not just challenging concealed carry laws like in Bruen, but challenging every kind of gun regulation that we have in place to keep our society safe. That goes for age minimum laws, for assault weapons bans, for sensitive spaces, all of it. So that was really where we left off with this post-Bruen chaos before we get to Rahimi, which is what we're dealing with today. Just a massive upheaval of our understanding of the Second Amendment in lower courts and how they've been able to approach judging the constitutionality of really important gun laws that we've had in place for decades and ones that we're trying to pass today to be innovative in keeping our communities safe. And so what I will say as far as March for Our Lives amicus brief, we did file an amicus brief in US v. Rahimi, both at the cert stage and in the actual stage once the court decided to take up this case. And I'm very proud of that brief. What we do are survivor storytelling amicus briefs at March for Our Lives. For those of you that don't know, an amicus brief means a friend of the court brief. We supply the court with different perspectives, different information, further context on what they need to know when they're going about these laws, considering if these laws are constitutional. And so for us, that looks like survivor storytelling amicus briefs, where we share the stories of survivors of domestic violence and gun violence and really show that this issue is a lot more than it seems at its face. So this law that's at issue in the case, US v. Rahimi, it's US Code 922G8, which bars those under domestic violence protection orders from accessing firearms, from possessing firearms. And that's important not just for people inside the home. I mean, women are 5 times more likely to die if their abuser has access to a firearm. That is very important. But what a lot of people also don't realize is the vast majority, it's around 70% of mass shooters, public mass shooters, are domestic violence perpetrators or have histories of domestic violence. So with these stories, we were able to show the court survivors of gun violence in the home, like Kate Ranta and her young son, Will. She was shot in front of him by her abuser. When he was just 4 years old, her toddler was in the room. His father shot his mother. The court was able to see the ramifications of that. When you let abusers that have restraining orders against them that have been proven to be dangerous by a judge, to let them have access to firearms, that has catastrophic consequences that we need to more intimately see how that plays out. And as well, we have survivors like those from Sandy Hook, Camille Paradis, who's now a teenager, who was able to tell us about the physical and mental and just the toll that gun violence takes on people that we don't see when after a mass shooting happens, and we don't get to see that aftermath when the next tragedy happens and we move on. There's lasting effects for survivors, especially when it comes to mental health. And that was something that we confronted the court with. We had survivors from Uvalde as well. All of these tragedies that we know by name, these epithets just that become a part of our public conscious. A lot of people don't realize that domestic violence has a big root in it. Like I said, those shooters all shot their mothers or their grandmothers or someone within their home, or exhibited violence against those in their families, people that they're close to, before going on to commit these tragedies. And that's something that people don't see, and they don't realize that what's at stake here is not just individuals, intimate issues that we have nothing to do with. This is about everyone. Every single person is protected by the law at issue in this case. And our brief is able to speak to that within the framework of the Bruen test. And we were still able to say, even when we're looking at history, we have a rich historical tradition in this country of taking firearms away from those that are dangerous and pose a threat to public safety. And we have a long tradition of doing that. Those that are the domestic violence perpetrators that have domestic violence restraining orders against them, we can consider them dangerous because of X, Y, and Z, everything I just spelled out, all the statistics that show us how they harm society, and all the intimate ways that these stories portray to us what these people have to go through when their abusers are armed with firearms. We were able to show, yes, domestic violence abusers are dangerous, and there's a rich history and tradition within this country of disarming those that are dangerous to the public. And so hopefully that lands with the court. I think it did in light of oral arguments yesterday, which we'll obviously talk about a little bit later in this. But yeah, I genuinely encourage anyone that can read that brief. It's online. And it's a really great way to position yourself in this movement of when we have all these legal arbitrary doctrines that are being debated, like you were talking about, Tonga, that there's a real human cost at the heart of this. And that's not something that should be removed, even in this new Bruen test that's all about historical laws.
Yeah, absolutely. And keeping on that human toll and test, I would love to pass to Joe and also hear about both the public health context now and also how it's evolved. Sometimes it can feel like the water that gets warmer year by year. So it's just, a whole generation is growing up and this is normal. It's just like we have this many school shootings, we have this many public shootings. Could you talk a little bit about how this is trending and what the major factors you're seeing in terms of public health and gun laws are coming out of this last 15 years from the regime the court has made?
Yeah, it's such a great point. I think, McKenna, you did such a fantastic job of really kind of framing, the issue and what we're facing right now. And I think, let me just, Tonga, just start by saying, we have spent, over a decade, right, getting people to understand that this is not, this has often been kind of, chalked up to being a criminal justice, problem or issue. This is a public health problem. And what that means is it means it's a complex health issue that is happening in cities and states all across this country, impacting, as McKenna, I think, nicely articulated, anyone and potentially everyone. If one person is not safe, none of us are safe. And I think if the Supreme Court allows the Fifth Circuit decision in U.S. versus Rahimi to stand, the outcome would be extremely dangerous, particularly for domestic violence victims and survivors, for children, and for our broader community. You heard, what McKenna said. Look, 2/3 of mass shootings from 2014 to 2019, the perpetrator either killed a family member or an intimate partner or had a history of domestic violence. Firearms are the most common weapons used in domestic violence homicides, with female intimate partners more likely to be murdered with a gun than by all other means combined. Just think about that for a second. And in fact, there's an average of about 70 women in America that are shot and killed by an intimate partner every month. And the mere presence of just having a firearm in those type of domestic violence situation increases the likelihood that a woman's going to be killed by fivefold, right? So this is a real issue that we are facing. And look, this doesn't just impact, the broader population as a whole. There's also a disproportionate impact when you think about underserved populations across the country, including Black and Indigenous women, women that are younger than 20 years old, pregnant women, people with disabilities, and members of the LGBTQ plus community who face disproportionately higher rates of domestic violence involving guns. So there will be dire consequences, Tonga, for victims of domestic abuse and for public safety if the Fifth Circuit, decision is allowed to stand. And I think that, right now is not the time, right, to throw out life-saving gun safety laws. Gun laws that protect victims of domestic abuse are among the most important public safety law in the country. And we saw both the pandemic, right, where there's an increase in gun sales that have been linked to more gun deaths. Meanwhile, by the way, frequent, mass shootings, right, continue to devastate the country, and the threats, posed by violent extremism and domestic terrorism are growing, right? In 2023, we are on pace, right, to be the year with the most mass shootings recorded in at least the past decade. And I don't think it's a surprise to anyone on this call that since 2020, firearms are the leading cause of death among children and adolescents. So I would just submit, that now is not the time to take away the tools that have historically protected us from gun violence. And in fact, we need to come up, right, with a multifaceted approach, right, that allows us to tackle this issue, right, from a systematic perspective, where we are tailoring solutions based off the different angles, right, of gun-related injury that we're seeing. And in this case, we're talking about domestic violence.
And I want to come back to you and follow up when you dive into the decision more, because there's so much there, and I think parts of the science that still even the court has not heard and internalized. But I as we keep laying the table, I want to talk to Poe about how this intersects with the politics of it all. In one aspect, what does this begin to take off the table? Like, is it still able to push forward politics around gun safety with the court we have? Are those on a collision course? And also, what have you seen that's able to break through? Because we hear these conversations, it makes sense to us, it makes sense to 55-60% of the country, and yet there seems to be this wall when it comes to Congress. So like, where do we have actual avenues to keep pushing forward on this politically?
Sure. So first, I want to, share that 83% of Americans support disarming domestic abusers, right? Majority of Americans support all the gun control measures that we support. But, we've been sleeping at the wheel. Essentially, the gun lobby has been playing chess while we've been playing checkers, or not even playing the game. They have been very involved in the efforts to move the Supreme Court for many years. And in fact, the NRA supported the blockade of Merrick Garland's confirmation. They also supported confirmation of Trump's appointees, Gorsuch, Kavanaugh, Barrett. And the NRA spent $1 million on ads for Kavanaugh's nomination. So they've been very involved. And on the gun control movement side, we've supported many of these. We did not support the confirmation of many of these judges because of their extreme positions on gun violence and gun rights. But I think we can move the Congress in the future. I know that we have been advocating for filibuster reform because, if we can win the Senate by a larger margin and demand that the Senate passes filibuster reform, we can pass many of the gun control measures and also work to expand the court. I mean, without filibuster reform, we can't. But I've shared earlier that we were able to move members of Congress to act on gun control measures after the Uvalde and Highland Park and Buffalo mass shootings last year. We were not able to move on the Senate side because we do not have filibuster reform yet. We need to, once we oust that, we'll be able to get 51 votes to pass the gun reform. So I don't think this is an intractable issue. We were able to pass Bipartisan Safer Communities Act with 15 Senate Republicans supporting the bill, as well as 14 House Democrats. And I mentioned this to Senator King and Senator Collins and Representative Golden for many years. And I said, it may not have happened to you yet, a horrific mass shooting, but if it can happen in Sandy Hook and Parkland and Highland Park and Buffalo and Louisville and Tennessee and in Nashville, then it can happen anywhere. And then sure enough, the mass shooting happened in Lewiston. And of course, on a daily basis, cities like Chicago and other areas, urban areas, are facing mass shootings on a daily basis. So I don't think it's intractable. I think that some of the Republicans will see that gun control is the high ground, and they need to support common sense, gun violence prevention measures to keep us safe. During the last decade since the Sandy Hook tragedy, there are 100 million more guns in the civilian market, and also 13.7 million more AR-15s. And the gun industry profited by $11 billion during that time. That is why we've seen 50% increase in gun deaths since the Sandy Hook tragedy. So we are in a more dangerous situation than ever before. And with easy access to weapons of war and other guns, this mass shootings and everyday gun violence will happen, over and over again. So, we're reaching that secondhand smoke moment, for all Americans. I think Americans are recognizing that it can happen in their communities. And because of that, they'll, have to vote on this issue to make sure that their children and loved ones come home.
I want to take us into the oral argument, and thank you for laying that out, especially with the secondhand smoke moment, because it is one of those things that could happen to anyone. Seeing this and then moving into the court. So listening to that argument, did hear an impression from several justices. They seem to agree that Rahimi himself is probably a dangerous person. It would be pretty untenable if this kind of person were not allowed weapons. And at the same time, they were looking very hard for connecting back to history. And I would like to hear from all of you, McKinnon as well, about how do you think we address this history issue? These are modern problems. They're as a modern social context, and yet this is the landscape that the court has set up for our laws to survive, and has even hinted that they might apply to future regulation coming out, which, things like red flag laws come to mind. How do we fit that in history? It seems kind of confusing to match those up. So I'd love to hear thoughts on how you're thinking about this issue.
Yeah, I can jump in here. I think there were a lot of great things that the Solicitor General pointed out in those oral arguments aligning to that test. And I think this is really important that all of us keep in mind. So one, in Bruen, the court explicitly said, these are historical analogs. We're not looking for historical twins. They don't need to be the exact same law at the founding as the ones that we're trying to pass now, word for word. And that is very important. But what has happened with this test is courts are then able to, when judges have to turn into historians overnight, depending on whatever ruling they wish to render, they can create a historical idea from it. They can really decide however harsh they want to hold these analogs to in that analogy. Do we want to make it a tight analog we're looking for, or do we want to give it a little more leeway? It really shows the ambiguity and the incoherence of the test at its core. But what the Solicitor General pointed out is that the Fifth Circuit Court in Rahimi, they really were looking way too narrowly at the relevant legal history that we needed by only considering the regulations that specifically talk about domestic violence or specifically tying Rahimi to some kind of individual at the nation's founding. And it is so important that we don't do that. And it's exactly what the court told us not to do. But I think it's just also shown the chaos that we've gotten in, where depending on what judge is sitting at that chamber in the courtroom across the country, the Republican judges consistently have been striking down 87% of laws since Bruen that have been stricken down have been by Republican justices. It really is. They have the leeway with this. And Prelogar said, it's important that this analogical test that we're engaging in isn't just about the specific text of the law, but about the reasoning as to why that law was instituted at the nation's founding, and analogizing it to the reason that we want to institute a law similar to that today, which is really important when we get into modern conversations, like what was entered in the chat when we talk about assault weapons bans, AR-15s that were surely not there at the time of the founding. They were dealing with muskets. That was a whole different, that was not your mama's gun, so to speak. And so what we've really been trying to portray in the litigation we get involved in, what we've been really peddling in our arguments is, the same reason that they instituted said law, so to protect public safety, is the same reason that we're enacting this law today. And we can analogize on the level of why we are doing these laws, how we're doing these laws, rather than what is the text of that law and what is the text of that law we're trying to do today. And like we said, that gets very important when we talk about how gun violence has evolved as a problem. It definitely was not present as a problem at the nation's founding, but like Dr. Joe has pointed out, like Poe was saying, like what we are dealing with is a whole different beast. Gun violence is so pervasive. It is an epidemic. It is not the same. We cannot be consigned to this founding history that was not dealing with the same problem. And especially when we get into the conversation about how women did not have rights at the time of the nation's founding, nor were Black people considered people at all. And so you get into this reliance on problematic laws that existed at the nation's founding. They disarmed Native Americans, they disarmed Black people at the nation's founding. And we at March have specifically said, even though those laws could be used to help our case, because, we're disarming what they considered to be dangerous people, we refuse to engage with that because it is odious. That was exactly what the Solicitor General called it. And I'm glad that Ketanji Brown Jackson pointed this out. Justice Jackson, it was a brilliant point. We are stuck in this history test from a history that is not favorable to large swaths of the public that exists in America today. And we shouldn't have to be relying on it. But what the Solicitor General did, and I commend her on this, is, they said, it's not necessarily that we are looking at these historical laws that are racist at their core as something that we should model. And we shouldn't say like, yes, they consider Native Americans and Black people dangerous, and so we can disarm dangerous people on that same ground, but rather took it and spun it and said, we're only using those laws to say the people who they considered people at the time are the ones that are protected under the Second Amendment, and that's it. And that's where the conversation ends. We're not relying on this problematic history, and it's something that I really wish the court would address when it issues its Rahimi decision. But I think that really just shows, from oral arguments, how the state of where we're at with this test is symptomatic of the test being not something we should be using at its core.
Yeah, I want to engage with that part. And if folks want to check it out, shameless plug, I wrote an article, Women and People of Color Deserve Better for the Second Amendment, on the ACS blog. But I want to ask and also invite Joe and Poe in. We're also seeing that people of color seem to have it both bad either way on gun disparities. Like they're largely the victims of gun violence disproportionately, but also when it comes to exercising whatever Second Amendment rights they have, they frequently are more criminalized, more targeted. And Indigenous folks, as someone in the chat has mentioned, how do we bridge and lift up those intersections while we're doing this work?
I can respond. Well, Professor Carol Anderson from Emory University, who wrote the book The Second, will argue that the Second Amendment was written and added to the Constitution to stamp out slave rebellion. So it was not an individual right to own and carry a gun. And also, the Black community has been disenfranchised in relation to the Second Amendment. But let's face it, this SCOTUS has been bought and paid for by the gun lobby. I mentioned the $1 million the NRA spent to make sure that Kavanaugh was nominated and confirmed. And this SCOTUS, which has been bought and paid for, has reconstructed the Second Amendment and fabricated the historic and traditions tests for gun control laws, which I believe is very unfair to all the gun violence survivors and future gun violence victims in this country. So, I would like to see the Heller and the Bruen decisions be reversed. And the only way we can do that in the future is with court reform. I would love to see additional justices be added to this court so we can start balancing the power, between the executive and legislative and this branch of government.
If I can just add just a couple things. First of all, Tango, I think, it's not a shameless plug. I actually saw your piece, which I thought was fantastic. And I think people would probably enjoy hearing you talk about it a little bit. But one of the things I think as we talk about marginalized populations, and this is broader even than the context of what we're talking about today as it relates to the Rahimi case. But when you think about what's happening in cities like Baltimore and Philadelphia and Chicago, right, and the structural violence and racism that exist, a lot of these are founded and historically linked to discriminatory policies of the past. Whether you're talking about redlining, right, with the Homeowner Loaners Act, or so many others, and we cannot ignore those because at the end of the day, only policy can fix what policy has created in the first place. And I think that's one of the pieces as we start to think about, people talk about the social determinants of health. Well, it's also the political determinants of health, right, that have led us to a situation where there is this inequity that exists that is resulting, right, in marginalized populations and underserved communities being disproportionately impacted. And the domestic, and intimate partner violence that we're talking about is one aspect of that. So I think it's so critical and it's so complex as we peel back these layers to really understand kind of the indiscretions of the past and how we tackle those.
Thank you. And I see, Poe, you want to respond on that or weigh in more on that?
I do. Earlier I said there are 100 million more guns in our nation than we had a decade ago after the Sandy Hook shooting tragedy. But, there is a major, racist ideology behind the proliferation of guns in this country. After, during COVID, Asian Americans were impacted by, hate incidents, and the gun lobby have marketed guns to the AAPI community to, arm us against others who are hurting us. So there is a racist component. And another fact is that, one of the reasons why the urban communities, the marginalized communities see disproportionate gun violence in their communities is because we have very weak gun control laws in this country where illegal guns can seep easily into those communities and are used for community violence. So, I'm really happy that the Invest in Us coalition is working to pass legislation that will secure $5 billion of investments for community violence intervention programs. But we have to address the issue of racism and hate in this country because those issues are used to fuel fear in arming more of us in this country. Right now, there are over 400 million guns in our country, more than every single, man, woman, and child. So it's really causing, unsafe communities all across our nation.
Let's talk about, and I've seen this from the chat, the looming constitution and the court. It's really, I think it's become clearer, the divide between what the court thinks and what everyday Americans think. And I'd love to hear folks weigh in a little bit more about what court reform looks like, the road to get there. Is there a road to is court reform enough? Is it a constitutional amendment? Like, really, how do we deal with this court? And, supposing that it's a it's a negative decision or lukewarm decision coming out in the summer. How do we build momentum for what we really need to see to make more progress on this?
So what I will say is court reform, contrary to people's popular thoughts, it is 100% legally sound. It is constitutionally written. Congress does have the power to change the number of justices anytime and has done so many, many times in history. When the founding fathers established the Supreme Court in the Constitution, they did leave the particulars about how many people sit on the bench, the scope of the bench's jurisdiction to Congress itself. So this isn't something that is just we're going too far with it. We're not doing anything that's constitutionally bound. That's not true. In 1790, there were 6 people on the court. After 1800, there are 5. And not only that, but throughout history, the number of people on the court has changed to serve the interest of the government. We increased it to 10 when it came to trying to create a pro-union majority bench to end the Civil War and to end slavery. The same thing can be said when the New Deal era came. We packed the court, so to speak, to save the New Deal and those kinds of policies that were essential to, helping the American public, and the status of our country. So it's not to say that this isn't something that is legally sound. It is. And it's also not to say that it's something that's never been done before, because it has been. And that is what is super important for us in March. I think, people have this idea that it's a radical answer to our problems, and it's not at all. If anything, I would argue that what we're dealing with is a very radical problem. We saw what happened last year in one term with the Supreme Court, roll back on so many constitutional rights that were long fought and precedent set for decades. And so for us, it's really important to acknowledge that, especially when it comes to the Second Amendment, like I was saying with Bruen, it wasn't striking down one law that really did the damage. It was writing this new test that we're consigned to until we get a court that is not a conservative supermajority and will amend that doctrine for us. And I can't say that this will be the court to do it at all. I don't think that that's the answer. And so there's a certain urgency of this problem. There's obviously an urgency of the gun violence epidemic, and we have hundreds of people dying each and every day. And there's 100% an urgency to rewrite this doctrine, because we also have Second Amendment litigation happening at lower levels and laws being struck down each and every day. And so that's all to say that it is something that can be legally supported, should be legally supported, and that's something that should enter the discourse and people should be talking about and thinking about. This is not a radical solution to a radical problem. If anything, we're asking for a fair and balanced court, not one that is just a liberal supermajority. We want a balanced court, and that's a reasonable answer to a radical problem, I would say.
I completely agree with McKenna, and I think the process has begun, because even those of us in the gun control movement have had conversations about filibuster reform. I think it's critical. We're not going to get 60 senators to support court reform right now, but I think that if we elect a few more Democrats, then we can change the filibuster rule and, be allowed to vote on gun control bills and maybe expanding the court, because that's what's really needed. Like McKenna said, this is a radical problem and we need a solution. And we don't think that, changing the filibuster or expanding the court is a radical, alternative solution for this issue.
These are like the big political issues, like, okay, we'll get more folks, but then also because I think there's like also the popular idea of the Constitution. So where do you see individual people plugging into this movement or making a difference? And what kinds of individual actions can make a difference from us?
Yeah, I mean, I could just start real quick and just say, it's interesting the way you asked that question, because I will tell you, like, I think most people individually, right, when you think about like why, so few people vote, is because a lot of people individually don't feel like they themselves, can make a difference. And in fact, the reality is that all of us are so critical to be part of this solution, right? I think for far too long, Tonga, a lot of these social issues that we face, whether it's gun violence or, name your issue, right? Immigration, climate change, the burden of these issues have been on the shoulders of a few people. And what we've started to realize in healthcare and so many other disciplines is that we're all have both the opportunity and the responsibility to be part of that solution. So where we start, frankly, is in our own community. Most, governing in America happens at the local and state level. I mean, think about where we are now. That's how you started out asking the question about, what's changed over the past 10 to 15 years. The culture is so different, right? We weren't even talking about these issues, 15 years ago. Why? It's because of the moms, pounding the pavement. It's because of young people like McKenna. It's because of the work of Poe and so many others that are unwilling and unapologetic to just simply sit on the sidelines of history as people get injured and killed. So I think it starts in our own backyard, in our own communities, linking up with other people that are doing this work to really be able, I think, to hold leaders and elected officials accountable. The reality is that prohibiting domestic abusers from accessing firearms is common sense, it's life-saving, and it's constitutional. And I think it's a full stop after that. And so it's our responsibility to really, I think, be an active part of this solution and to really engage the individuals around us for this.
I want to say gun violence is a huge, public health crisis, like Joe mentioned earlier. And there are so many more gun control advocates since the Sandy Hook tragedy. Every time there's another, shooting tragedy, more and more people join the movement, and the movement is bigger than ever before. And one thing that I'm not seeing is all of gun control movement participating in efforts to end the filibuster or pushing for court reform or, pushing for voting rights, those type of democracy issues. And I really think that the gun control movement has to step in and work intersectionally with the democracy groups and address this issue, because we can't pass and protect our gun control bills without resolving the democracy issues.
Yeah, I very much agree with Poe on that point, and I love it what's been said thus far. I think it's really important in this movement. People think gun violence prevention looks like fighting just for bills that pertain to gun violence, and that's it. And that's not true. There is an underbelly to this. That, like I said, the court has such an inextricable role in setting the playing field for how we engage with protecting ourselves from gun violence. They are what decides if a certain law will stand or if it falls. They're what decides what we can and can't pass. And so who's sitting on that court? We obviously have a very large vested interest in. And that's something that needs to be talked about more in our discourse. And something we've tried to do is, educating the younger generations and educating members within our movement that court reform is inextricably linked to our ability to curtail gun violence. And that's really important. It's part of our duty. As society progresses, we've been able to progress on how we understand and accept people and the different ideas that we engage with. And what this court has done is consigned us to this history where we're not able to do that. And there's no other constitutional right that exists out there. There's no other amendment that's tied to the same kind of test where we are stuck in 1791 or 1868, depending on how the courts look at it. But that's all to say that it is really important for us to have that as part of the conversation. So on the individual level, yes, this is something that people should be talking about and really adding into that public discourse when we're talking about gun violence. And as well, I will say there's a myriad of bills that we have signed on to and, that this coalition supports, and that's super important. And I know that representatives that have introduced these bills, like the Judiciary Act, are looking for that kind of call, that signal from the public that that's what they support. We have these large public opinion polls that tell us that the overwhelming majority of the public wants change in the courts. But, calling your representatives, expressing that kind of interest in this, and especially from the gun violence prevention lens, is something that you can do on the individual level, something that's easy and really promotes civic engagement. And I really think something that can help our movement in getting this kind of very much needed reform.
This is brilliant. I've got one last question in our remaining time, and it's despite the heaviness of this conversation, I do predict I'd be surprised if this report doesn't rule in our favor, at least narrowly, this summer. Probably around June, July, we'll see that decision. And sometimes a a positive court decision can be tough for movement building, because then the public's like, well, it's solved. It's no longer a problem. So I'd just love to hear your thoughts on, like, what should we have in mind the day after? What are the new battles that we are taking this decision to advance? I think that was something that the conservatives did very well with their victories last summer. They ran full gas to the pedal. So what are the kinds of things that you would like to see folks do on June 15th, say, after this decision comes out?
Yeah, so it's looking very likely, hopefully, fingers crossed. I don't want to, spoil this, but it's looking likely that they will uphold the federal law that bars domestic violence users under restraining orders from possessing firearms. That being said, and if you read the stories in our brief, you'll see this. Nothing bars domestic violence abusers from going out and buying another firearm after their firearms are removed when they get a restraining order against them. There are so many gaping holes in our system that still put us at risk of gun violence, and especially the victims that are right there, in the line of fire for that. And so just because we get one court victory on this law, God willing, we do, that doesn't mean that our fight stops. That doesn't mean that there's not much more that needs to be done. So that's hopefully what we can galvanize people around. And something that I really hope spreads in the message is that, one win does not mean that it's all over. That's one battle that's won, but gun violence epidemic, this is a war. And we have to keep fighting until the very end to make sure that we make gun violence obsolete once and for all. And that being said, too, like I said, with this test, there's kind of multiple levels and multiple battles we're fighting within this one case. And so, yes, even if the court does uphold the law, that test still reigns. That doctrine is still what we're fighting right now. And I don't have any hopes that they will just scratch the test and create a new one. Unfortunately, it would be great if they did. If anything, they're either going to ignore it completely, or they'll clarify the parameters for it so that the lower courts aren't scrambling as much as they are, and we'll have more cohesion in the lower court system as far as how this test is applied. But that being said, there's still a fight that needs to be done. And I don't think that test is going to be rewritten or unwritten until we have the court reform that we need. So like I said, no matter what happens with Rahimi, whether we get a win and this law is upheld, or whether this test stays, we still have a fight that keeps going. And domestic violence isn't the only issue when it comes to gun violence. Like we said, there's so many pervasive forms. There's so many other laws we need to be fighting for: protections for firearm suicides, extremist protection orders and red flag laws, age minimums, assault weapons bans. The list goes on and on and on. So never tired in this movement, never tire of it, because we still have a long fight ahead of us. If anything, use the win, the hopeful win from Rahimi, to galvanize all of us that we can get this done.
Absolutely. Joe?
Yeah, I was just going to add on. I think, McKenna, you did a really nice job of kind of summarizing all the different things that we can do. And I think that the point here, I mean, you kind of really made the case of why this is a public health issue. People always say, well, what's the one thing, that you would do? Well, there is no one thing, right? It requires this, multifaceted approach. And as you heard McKenna just say, right, even, hopefully the Supreme Court, right, is gonna keep this important protection for domestic violence survivors in place, right? But even with that, right, we need to expand, right, the Brady background check. We need to do the permit to purchase. We need to make sure states have extremist protection orders. We need to pass Ethan's law. All of those things, right, that will allow us to shore up, the different kind of methods of, gun-related injury that we are seeing in America. And that is kind of at the core of why this is a public health problem. And I think that's something that, like, yes, this is going to be important, but this is, yet one more step in the direction of trying to make, communities safer.
Absolutely. And Poe, I'll give you the last word.
Well, I just want to add that where there are more guns, there are more gun deaths. Where there are stronger gun laws, there are less gun deaths. And this nation, I mean, we don't have the gun laws that we need to protect Americans, as evidenced by 38,000 gun deaths this year and nearly 600 mass shooting incidents, according to the Gun Violence Archive. So we have a lot of work ahead of us to pass stronger, more comprehensive gun control measures on a federal level, as well as on the state level as well. So we have a lot of work to do. This case is, if we win it, great. It's one step in the right direction. But as we've seen, it's like one step forward and 3 steps backwards. That's what I've witnessed in the last 11 years in my advocacy work. So we have to act urgently, and we have to continue to push boldly, unapologetically, and be aspirational in our approach. You know, we can't be satisfied with one little win in the court because, as I said earlier, that the NRA and the other gun lobby groups have been playing chess, strategically making sure that they have the extreme majority in the Supreme Court that they wanted to rule their way so they can sell any guns to anyone. And so we need to work harder to make sure that we can protect our kids and families, because right now we're living in a more dangerous world than a decade ago when Sandy Hook shooting happened.
It is such a long road ahead. I'm glad that you all are marching it. I really appreciate you taking the time to join us on this call. It's been wonderful learning from you, and encourage folks to find you on social media, on the internet, follow your orgs. I also really want to call out the chat. So many people are sharing heartbreaking stories about the people that they've lost to gun violence, how they got involved in this fight. And I really want to thank you all for taking the hour of your day to come and listen to this and for the work that you're doing outside of it. Much appreciated. This will be the end of our webinar, and we'll just pause for like a minute to make sure that we've got the recording down, and everyone enjoy your afternoons and evenings. Thanks.